Hello, welcome to session 4 of our course on international criminal law. This session marks the beginning of the second substantive part of the course, and that is, rather than focusing on the criminal conduct per se, we would look at how an individual may come to participate or get involved in the commission of such conduct, and therefore giving rise to his or her individual criminal responsibility under international criminal law. So this is what many criminal lawyers and scholars would refer to as the general part of criminal law. Before we get started on this particular area, I need to highlight where in the broader scheme of things, when it comes to responsibility under international law, this particular topic finds itself. So if we go back to the hypothetical killing of Professor Kanada by me, so that's one act that could potentially constitute the war crime of murder, the crime against humanity of murder, or the crime of genocide by way of killing. This one act could attract simultaneously and independently of each other, at least conceptually speaking, 4 distinct kinds of responsibility. The first kind of responsibility that would come to mind for most international lawyers is, in fact, that of state responsibility. And when international lawyers speak of state responsibility, it invariably refers to the kind of non-criminal tort liability. I think the concept of state responsibility under international law comes closer to the concept of tort liability in domestic law, although there are some differences. And if, for example, I kill Professor Kanada, and this act of killing is somehow attributable to a state, for example, I happen to be an official of a particular state, and I kill Professor Kanada acting in that capacity, while acting in that capacity. In that case, my act could be attributed to the state that I represent, and therefore is potentially capable of holding or creating international responsibility for the state that I represent. Another possible kind of responsibility, although this one remains hypothetical or theoretical as it stands today, and that is the criminal responsibility of a state. So assuming that my act of killing Professor Kanada is attributable to a state that I represent, could a state be held criminally liable under international law for this? At least as international law stands today, we mentioned earlier how the criminal responsibility of a state is not a generally accepted concept. If you think about it, given how corporate liability is developing rapidly in some jurisdictions, some domestic jurisdictions, and corporate entities, such as companies and organizations, are much like states. States themselves are corporate entities. So, in principle, there is no compelling reason why states should be seen as incapable, fundamentally incapable of assuming criminal responsibility, because it can happen in domestic law, so why not under international law? The fact of the matter is that international law has not progressed to that point where we can speak about international criminal responsibility of states. So it's a theoretical possibility. The third kind of responsibility under international law would be that of individual tort responsibility, civil responsibility. So if I kill Professor Kaneda, I commit a wrongful act, and his family, for example, might be entitled to claim compensation from me on account of the wrongful conduct that I commit. Again, whether this is also a matter of criminal liability is a separate question. I think the perfect illustration concerning the separate existence of civil liability and criminal liability is when we look at the O.J. Simpson case. So although O.J. Simpson was acquitted at trial, that is, as far as his criminal responsibility for the killing of his wife was concerned, he was acquitted. But the family of the deceased wife successfully sued O.J. Simpson for damages caused by the wrongful death of the wife's wrongful death. And the family was successful in securing millions of dollars in compensation from him. So why not on the international plane? At least theoretically, I could somehow incur civil liability by killing Professor Kaneda under international law. Although this remains a possibility, this has not been, in a way, generally embedded in international law. The successive presence of the two ad hoc tribunals, that is the Yugoslav and Rwanda tribunals, have unsuccessfully petitioned the UN Security Council that had created these two tribunals in their efforts to amend the statutes, empowering those tribunals to award compensations to the victims. So the idea was there, but I didn't see fruition in the way, in the form of an amended statute empowering the judges to award compensation. This is interesting because the Rome Statute of International Criminal Court, in its Article 55, paragraph 2, in fact empowers the ICC to award compensation for the victims. More specifically, the ICC is empowered to order the convicted person to pay compensation to the victim. So this is, properly speaking, a form of civil liability on the part of the person causing damage, wrongful consequences. So it's quite novel. The only other jurisdiction that I am aware of is the extraordinary chambers in the courts of Cambodia, the ECCC, because the ECCC is heavily influenced by the French continental legal tradition. Cambodia used to be a French colony. Was it a colony? Yes, in Indochina. So there's a heavy French influence in the way the lawyers administer Cambodian law. And because typically continental court is empowered to adjudicate both civil and criminal claims in the same trial, the ECCC follows that model and hears the civil parties representing the victims of the crimes committed in Cambodia, while the criminal trials of the accused persons go on. So this is the individual civil liability under international law is moving forward, although perhaps too slowly for many people's preferences. So that's the third kind of responsibility under international law that may concurrently exist if I kill Professor Kanada. The final and the fourth kind of responsibility that may arise as a result of me killing Professor Kanada is the individual criminal responsibility under international law. And this is where our topic stands. So if I can schematically present how our thinking proceeds, you have, first of all, punishable conduct. And then you add modes of liability, as we call the types of individual criminal liability under international criminal law. So punishable conduct plus modes of liability. And then from that, you subtract any successful defense pleas. For example, the justificatory defense of self-defense or duress as an excuse. Then if you do this math, as it were, punishable conduct plus modes of liability minus successful defenses, then you would have the degree of culpability that would go into, for example, sentencing considerations by the judges. So that would be the basis that would inform the judges when the judges decide on the penalties. So we are at stage 2, as it were. Having gone through punishable conduct, how do we place an individual in relation to that punishable conduct so that we can come up with the totality of the picture of culpability surrounding this individual, subject to, of course, subtractions through successful defense pleas that would come later. So that being the case, let us look at modes of liability a little more closely. As a matter of general considerations, there could be one or more individuals that would be involved in the commission of a crime, and therefore each of them eligible for some form of criminal liability. In the case of me killing Professor Kanada, we have been saying that I am the person who actually commits the crime, so I'm obviously involved in it. But then I also use the example of a third person lending me the knife that I used to kill Professor Kanada. So where would that third person be situated in this landscape of liability? One could even add more individuals into the picture. For example, what if I am ordered by somebody else to kill Professor Kanada, where still somebody pays me? Let's say I'm a professional assassin and I kill for money. So if somebody basically pays me to kill Professor Kanada, what kind of liability would cover such a person? What if I am a member of the armed forces of a state? In other words, I belong to a military unit, and my superior officer, my commanding officer, let's say, knows that I'm about to kill Professor Kanada and does nothing about it. could my commanding officer, under the right circumstances, be held criminally responsible for the crime I commit? All these are possible scenarios where someone other than, besides myself, might be held criminally liable for the murder I commit. So immediately, there emerges the need to somehow make sense of these different individuals playing different bits of the event. Drawing primarily on how domestic criminal law deals with matters like this, international criminal law also follows the notion, broadly follows the notion that distinguishes between, let's say, modes of principal liability. In other words, if I kill Professor Kanada, I am the principal offender in this crime. On the one hand, and on the other hand, other derivative or secondary modes of liability, variously known as, for example, accessorial liability or accomplice liability, or what's the word? A complicity liabilities. When one draws such distinctions, that is, principal liability on the one hand and secondary liability, accessorial, accomplice, or complicity kinds of liability on the other hand, one also typically implies by such distinctions the different degrees to which the person implicated would be deemed culpable. So when someone is held as under a principal mode of liability, usually the idea is that this person incurs the most incriminating kind and degree of culpability. Whereas if someone else is a minor player, then this person's liability would be more limited and would be seen, this person will be seen as less culpable as a result. Now, under international criminal law, this distinction and therefore the associated notions of culpability generally holds true. But as we will see in a few minutes, the fact that someone come under a principal mode of liability does not always give us the result that this person is therefore more culpable than an accessory, special kinds of accessory who might be seen as deserving even greater degrees of culpability than the principal offender. This kind of reversal, or let's say, the possibility that individual criminal liability under international criminal law does not necessarily follow this principal versus accessorial modes of liability, and therefore the greater and lesser degrees of culpability is the reason why the international criminal doesn't follow this necessarily is the peculiarity associated with international crimes. So let's say that when we think of murder in an ordinary setting, we typically imagine one person killing another person. So there is not much, let's say, complexity in the picture. But what if we deal with organized crime? So let's say there is a mafia, or even some criminal gangs, and not everybody participates in the killing of a person, but there is this sort of a leader or a kingpin somewhere telling others what to do. So it's possible that the person who actually kills the person is simply acting on orders issued by somebody else. What this suggests, by the way, the same goes even for sophisticated white-collar crimes like fraud, large-scale banking fraud. You have a lot of people doing bits and pieces of what would eventually amount to fraud. So it's not always straightforward to identify the one principal offender and then say the rest is basically secondary. The picture can be a lot more complicated and more nuanced than that. War crimes, crimes against humanity and genocide tend to require the participation of a large number of individuals acting sort of separated in time and space. So not everybody is at one location at the same time. A lot of people do different parts of the machinery that eventually ends up in the commission of large-scale war crimes, so crimes against humanity and genocide. But these people are separate in time and space. So what that means is that such crimes very often, if not always, require a high degree of coordination and participation of different kinds. So if we are only left with basic modes of liability and simple notions of principal and accessorial kinds of liability, so that this person is most culpable because he's the principal and that person is less culpable because he's an accessory, that simple picture kind of breaks down. And we might end up missing the location of the person who is truly the most culpable. So if we can imagine, let's say in the case of, in a genocide case, the killing takes place on a field somewhere where you have military units basically dispatching victims with machine guns. These people are the ones that dirty their hands, but the person possessing the genocidal intent may not be at the crime scene. This person may in fact be sitting hundreds of kilometers away somewhere in a very tidy, sophisticated office, smoking cigars or something like that. And for crimes like these, we are going to have to develop and apply an array of different kinds of modes of liability, and without being tied to the kind of mechanical implications when it comes to the degree of culpability. So although the direct perpetrator, the principal offender of the killing of genocide may be the rank and file soldiers in the field, if the crime in question is genocide, clearly they are not the ones deserving the greatest degree of culpability. In fact, the person sitting in this office hundreds of kilometers away from the crime scene, smoking cigars and saying all the right things in public, might be not necessarily the principal offender. He or she may somehow only be caught under some accessorial mode of liability, technically speaking, but we know better than to say that because this person is an accessory, the degree of culpability ought to be less than those who are in the field and killing people. So we need to be careful when we borrow concepts of criminal liability from domestic jurisdictions and try to apply them in the context of international crimes, complex ones such as war crimes, crimes against humanity, and genocide. So this is a caveat that we need to keep in mind as we go through the list of modes of liability available under international criminal law. When going through the list, if there is such a list, we shall see in a few minutes, of modes of liability that are available under international criminal law, we need to keep one thing in mind, and that is that the sources that we need to consult when attempting to identify this or that mode of liability under international criminal law vary tremendously. The situation is more or less the same, or arguably similar at least, when trying to identify what kind of war crimes there are under international criminal law and what kind of crimes against humanity there are under international criminal law. Genocide is very tightly defined, and the definition has survived the passage of time since 1948. But when it comes to war crimes and crimes against humanity, because there is no definitive list of these crimes under international criminal law today, we need to keep searching for relevant sources of such crimes. And that remains true even when we have got Articles 7 and 8 of the Rome Statute. The list of crimes against humanity under Article 7 and the list of war crimes under Article 8 of the Rome Statute are definitive and closed as far as the ICC as a court is concerned. The ICC is bound by what's in Article 6 and Article 7 and Article 8 when it comes to the list of crimes against humanity and genocide. But that does not mean that there is no, if not listed under Article 7 or Article 8, then whatever you're seeing is not a crime against humanity or a war crime. Quite the contrary, under customary international criminal law, there could very well be a crime against humanity or a war crime not listed, or not listed in the same way as under Articles 7 or 8. Modes of liability under international criminal law are very similar, arguably. But I would say that the situation is worse for modes of liability. If you go back to the Nuremberg Charter, for example, there is no separate provision on modes of liability to begin with. So when you go through the judgment, basically you are left to your own devices when trying to identify, oh, this person is convicted of this crime under that mode of liability, because it's not very clearly stated in the judgment. The situation became slightly less confused and confusing when the two ad hoc tribunals were created in 1993 and 1994, respectively, by the Security Council. The two statutes, Article 7 of the ICTY statute and Article 6 of the ICTR statute, did enumerate the modes of liability that the respective tribunals were to apply in the cases that would come before them. But even then, it's just a very rudimentary list of what appear to be distinct modes of liability: committing, ordering, instigating, planning, and so on and so forth. But no elaboration was to be found in the statute or any of the associated documents. So the judges had to interpret them as they went. So the sometimes messy and often inconsistent case law that has come out of the Yugoslav and the Rwanda tribunals. And to add to the confusion, you have other ad hoc jurisdictions like the Special Court for Sierra Leone and so on, adding their own voices to the plate. So you have to, when we try to discern the content of, for example, commission as a mode of liability, then you need to go through the case law of these jurisdictions with a view to distilling what is required in terms of, for example, elements of commission as a mode of liability. Article 25 and Article 28 of the Rome Statute give the ICC the definitive list of modes of liability available to it. Here too, the way in which many of those modes of liability you find in Articles 25 and 28 are in fact dissimilar from their customary international criminal law counterparts, as it were. So you need to constantly compare the case law that has come out of those ad hoc jurisdictions on similar sounding modes of liability on the one hand, and on the other hand, see what kind of cases have come out of the ICC on this or that mode of liability you find under the Rome Statute. So it's a very sometimes frustrating exercise, and because there is no document like the Elements of Crimes document that would assist us when interpreting specific war crimes, crimes against humanity, and genocide in even the act of aggression, a crime of aggression under the Rome Statute, there is no such documentary assistance for when it comes to interpreting modes of liability under Articles 25 and 28. So our exercise is not helped by the lack of such secondary documents and authorities. If you take a look at Articles 25 and 28 of the Rome Statute, you would see, depending on how you count them, 7 distinct modes of liability. So first of all, you see commission, although commission can be kind of disentangled into different kinds of commission already. So it's not always straightforward to say that commission is one mode of liability, but let's say that's one. And then you have ordering, soliciting, or inducing, that comes next. And then aiding and abetting or otherwise assisting, that's the third, that's listed under Article 25, paragraph 3. And then you have contributing via common purpose, that's the fourth. And then you have indirectly and publicly inciting. This is specific and limited to the crime of genocide. And the sixth one is attempting. Attempting is subject to abandonment as it is stipulated in the provisions. That's the sixth. And then the seventh one is the superior / command responsibility that appears under Article 28. Already, we know by comparing this list under Articles 25 and 28 of the Rome Statute on the one hand, and on the other ad hoc instruments, we can see that certain modes of liability are, shall we say, missing in the Rome Statute. Planning is not there. Instigating is not there. Instigation is an interesting mode of liability because it arguably covers incitement. But as we see, incitement, especially a direct and public kind of incitement, is limited to genocide. And that comes from the fact, this limitation when it comes to directly and publicly inciting the commission of genocide comes from the terms of the 1948 Genocide Convention itself. So instigation is arguably a broader scope that encompasses this particular kind of incitement, public and direct, but also other kinds of incitement. So what does that tell us? Under customary international criminal law, a jurisdiction such as the ad hoc tribunals or subsequent ad hoc tribunals, if the Security Council or other entities choose to establish them, then they might have access to instigation encompassing not only direct and public incitement to commit genocide, but also instigating the commission of other crimes under international law. That's an option that is not available to the ICC, as we can see. Planning is completely gone from the Rome Statute. Although you might say that attempt would cover it, attempt under the Rome Statute is interesting too, because as far as we can see, attempt is not, it could apply to all crimes listed under the Rome Statute. In contrast, if you go to the ad hoc tribunals statutes, attempt is in fact limited to genocide. And that limitation under the ad hoc instruments also comes from the 1948 Genocide Convention. So on the one hand, the ad hoc instruments, the drafters of the ad hoc instruments had chosen to be faithful to the 1948 Genocide Convention when it came to attempts, but not instigating, for example. On the other hand, those who drafted the Rome Statute in 1998 chose to be faithful when it came to incitement and limit it to genocide, because that's what the Genocide Convention contained, but then chose to be quite liberal when it came to attempts, because, well, why not make attempt as a model of liability available to not just genocide, but other crimes as well. So there is a sense that the kind of list you find in each of these instruments is basically the result of some sort of arbitrary decision taken by those who had drafted them. So, be that as it may, let's start with commission. Commission is the principal moral liability you see in the Rome Statute, and it is treated as such under customary international criminal law. Here, the caveat, as I mentioned earlier, is that those who actually commit certain of the international crimes that we are talking about may not turn out to be the most culpable ones. So the trigger pillars on the ground when it comes to genocide or crimes against humanity and so on may not even possess the requisite genocidal intent if we are looking at genocide. So the Rome Statute lists three kinds of commission. One is commission simplicitaire, as it were, the direct commission. So if I kill Professor Kanada, I committed the crime of murder single-handedly. But one could jointly commit a crime. Could he not? Let's think of torture, for example. Torture is a sort of a very good example when trying to understand when a crime can be committed jointly by more than two persons. And in fact, this is drawn from a real case before the ICTY. So I could be sitting behind the desk and asking questions of a prisoner. My colleague might be standing beside the prisoner, and on cue, he may inflict severe physical pain on the prisoner for refusing to answer my questions. Because of the way in which torture is defined as a war crime and also as a crime against humanity, different elements of torture may be committed by multiple individuals. So the infliction of severe physical pain is an element of torture. But the mere infliction of such pain does not itself amount to torture. what is needed is the specific intent, or the dolus specialis, whereby the pain is inflicted with an intent to achieve several things. For example, extracting information is one eligible intent. So if I pose questions with a view to extracting information from the prisoner, then I exhibit this specific intent, dolus specialis. And my colleague standing beside the prisoner does the infliction bit. So together, he and I jointly commit the crime of torture, wouldn't we? This is a quintessential illustration of when a crime can be committed jointly. So both of us are principal offenders because we fulfill different elements of the crime together. So that's already envisaged in Article 25C 3A. So besides sort of commission simpliciter, we have joint commission, or you have a commission through another person. And the guilt or innocence of that other person is irrelevant for the purposes of establishing commission. We call it indirect commission. To give you an example of when a crime can be indirectly committed, let's say I want to kill Professor Kanata again. So what I do is I create a package containing an explosive that will detonate when the packaging is tampered with, or sort of when someone tries to open it. And I post it, addressed to Professor Kanata. The postal service personnel who actually delivers my parcel to Professor Kanata is the innocent instrument here. So I commit his murder, but through another individual who in fact actuates the actus reus of killing him. A key element in this kind of control is that the postman clearly doesn't have the mens rea of murder. He doesn't even know that he's playing a part in this crime that I'm committing. So this is indirect perpetration or commission captured by the Rome Statute. What is interesting about this particular model of liability is that in some cases, the judges have chosen to combine joint commission with indirect commission. So if a crime can be committed jointly, in other words, by more than two people acting together, surely that joint commission can be done indirectly too. So you are basically combining joint commission with indirect commission, and what we end up with is the so-called indirect co-perpetration. For reasons that I would hope becomes clear later, I would propose we not pursue indirect co-perpetration at this stage, because it actually fits better when we discuss indirect co-perpetration together with joint criminal enterprise. So that's the principal mode of liability that the Rome Statute gives us. Next up is ordering, soliciting, or inducing. This is more or less a reflection, and it closely follows the customary law counterparts, so I'm not going to say much about them. The third mode of liability listed in Article 25.3 is something I would like to spend some time on discussing. So the technical term is aiding, abetting, or otherwise assisting. So the AAA, AAA. Its customary law counterpart is known as aiding and abetting, or aiding or abetting. So it's AA, not AAA. Or otherwise assisting is not part of the expression. I'm not sure we should pay too much attention to the phraseological difference. That is, AA under customary international criminal law and AAA under the Rome Statute. But what is significant is that in the Rome Statute, this mode of liability begins with for the purpose of facilitating the commission of a crime. This addition and reference to the purpose of facilitating the commission of a crime has been interpreted quite widely to imply that this mode of liability requires some sort of a purposive element. And the requirement of a purposive element clearly distinguishes this AAA, aiding, abetting, or otherwise assisting, from its customary law counterpart, aiding or abetting. Aiding or abetting, as developed through the jurisprudence of the ICTY, the ICTR, and the Special Court for Sierra Leone, at least in its latest incarnation, does not require any sort of purposive element. What is required is the knowledge on the part of the aider or abettor that what he or she is doing has a substantial influence on the commission of the crime. Although this is not very important, in fact, there was a time within the jurisprudence of the jurisprudential life, shall we say, of the Yugoslav Tribunal, where the so-called specific direction was seen as a requirement of aiding and abetting. So in addition to the provision of substantial influence on the commission of the crime, and the knowledge on the part of the aider or abettor that his or her action was providing such substantial influence, it was said that the provision of this influence or assistance had to be for the specific purpose of specifically directed towards the commission of the crime. There was, in fact, a quite lively disagreement amongst the judges at the ICTY and the Special Court for Sierra Leone, but in the end, the appeals chamber's most recent ruling, which is the settled law for customary international criminal law, is that specific direction is not an element of aiding and abetting. So what you end up with is, under customary international criminal law, is that if you provide substantial assistance in the commission of a crime by another person, and if you do so in the knowledge that you are providing such assistance, then you are an aider or abettor. Crucial. You don't need to share the intent of the person who commits the crime. So coming back to the killing of Professor Kaneda, I'm the direct principal offender. I performed the actus reus of murder, and I possess the mens rea of murder. So I either intend to kill Professor Kaneda, or I act in reckless disregard of his life in acting this way. but I borrow a knife from a friend of mine in order to commit this crime. So the provision of a knife under certain circumstances would clearly amount to the provision of substantial assistance in the crime I commit. Of course, I could use my bare hands, but let's say that the circumstances are such that me having a knife significantly facilitated the crime of murder. And this friend of mine, whereas he, let's call it he couldn't care less one way or the other whether Professor Kanada lives or dies, but he does know that I want to kill him. So if he gave me the knife that I request from him, and if he knows that I'm going to kill Professor Kanada with his knife, then arguably he just aided and abetted in the crime I committed. Aiding and abetting understood this way is it's a classic illustration of complicity. The provision of substantial assistance sometimes doesn't even need to be something active. Omission itself could amount to a substantial assistance in the commission of a crime if there was a contrary duty to obligation to act, but the person in question omits to do so. So culpable omission in a way. Then this omission may also amount to aiding and abetting. The question is quite troubling. The question that follows this could be quite troubling. Let's say that you are a humanitarian worker trying to protect civilians in the field where there are armed hostilities all around. And let's say that an enclave is encircled and besieged by one of the warring parties in the conflict. So people inside this besieged enclave starve. And unless you do something, they actually die. So what do? If you're the humanitarian worker with limited resources and the time is ticking, you might find yourself agreeing to evacuate the people trapped in this siege. What if the intent behind the siege is to ethnically cleanse the area? So the warring party besieges this locality because this locality is inhabited by members of a rival ethnic group. So you want to make life impossible for those inside. And well, here comes the humanitarian organization ready to assist you in evacuating the people in this locality. So once they have been evacuated, it's for you to take. And you just cleanse the area ethnically. If as a humanitarian worker, you essentially help evacuate these people, well, that's substantial assistance, arguably, in the commission of forcible displacement. It's a crime against humanity and also a war crime. And although you clearly do not intend to commit these crimes, you know that the besieging party does. Well, then didn't you just aid and abet in the commission of forcible displacement as a war crime or crime against humanity? Because that is what customary international criminal law arguably tells you. A problem like that would not happen if we look at the Rome Statute, because of this added for the purpose of facilitating the commission of a crime when applying aiding, abetting, or otherwise assisting as a mode of liability. In the scenario of this starvation and emergency evacuation, you clearly do not evacuate them for the purpose of facilitating the crime of forcible displacement. You do it because otherwise they would die. So there is a safe valve built into Article 25(3)(c), but not so under customary international criminal. So there is an unresolved problem when trying to delimit the scope of aiding and abetting, customarily speaking. One could say that although leadership figures and masterminds away from the crime scene are perhaps not direct perpetrators of mass killings, they could be aiders and abettors. Because of what they do, they provide substantial assistance in the commission of the crime on the ground, and they at least know that the crime will be committed as a result of their assistance. So wouldn't that be at least enough to sort of catch them under some mode of liability? Because of the perception, this is an enduring perception, I must say, that aiding and abetting is some sort of a lesser mode of liability. It's a mode of liability widely seen as engaging a lesser degree of culpability. One might find himself or herself wanting to sort of upgrade this mode of liability to something else. Well, first of all, if the masterminds and leadership figures not only knew that the crimes would be committed as a result of their assistance, but also intended the crimes to be committed, albeit remotely, then aiding and abetting wouldn't even be a suitable mode of liability, because that would leave certain crucial bits of the facts uncovered or unaddressed, unaccounted for. So you artificially diminish the person's culpability by calling this person an aider and abetter, rather than, for example, as we discussed briefly a few minutes ago, an indirect co-perpetrator, because indirect co-perpetrators are said to be those who possess the mens rea of the crime with which they are charged. Aider and abettors, by definition, do not require such an intense degree of intent. Mere knowledge would suffice. Customarily speaking, even under Article 25(3)(c), what is required for aiding, abetting, or otherwise assistance is simply that there be some sort of a purposive element in order to facilitate the commission of the crime. You don't even have to intend to commit the crime yourself. There still, the degree of mental state implied in these characterizations would risk falling short of what you're really trying to point out by holding this person fully criminally accountable. So what do we do when it comes to those remote individuals, away individuals who bear the greatest degree of responsibility, but away from the crime scene? One avenue pursued by prosecutors at the ICC, and finding some support by some of the judges at the ICC at least, is indirect co-perpetration. There are that the indirect co-perpetration is a mode of liability, arguably a mode of liability available specifically under the Rome Statute because of the way in which Article 25(3)(a) is written. Customary international criminal law, it's not clear whether customary international criminal law has the exact counterpart, indirect co-perpetration. In fact, the prevailing view is that it doesn't. What it does have instead is the so-called joint criminal enterprise, or JCE. So that's one way under customary international criminal law to go after the high-profile leadership figures and masterminds. People like Mr. Milosevic, for instance. There is another mode of liability that was once considered available. This particular mode of liability is sort of going out of flavor. And the reasons for that would hopefully become clearer when we return for session 5. And this is the responsibility of the commander or the superior. Both JCE and command/superior responsibility are modes of liability that are perhaps maybe not unique to international criminal law, but they are uniquely reflective of what international criminal law is about. As I said earlier, it's not what happens on the ground that really characterizes the atrocities that the international community is trying to address. It is the degree of organization or the degree of extent of coordination and the participation of different kinds of individuals at different points in time and place. So when we return for session 5, we will take a closer look at these two special modes of liability, namely joint criminal enterprise and command/superior responsibility. I suggest we start with the latter. In fact, command/superior responsibility is basically a mode of liability built on the failure of a commander or a superior to do anything or to do enough when his or her subordinate has committed the crime. So it's basically a mode of liability built on your failure to act. Joint criminal enterprise is a mode of liability that captures group efforts, basically. We will use the hypothetical scenario of a bank robbery in order to illustrate some of its salient features. And then once we have gone through joint criminal enterprise and command/superior responsibility and joint criminal enterprise, we would then move to the so-called defenses. If you remember, it's the punishable conduct plus mode of liability minus successful defense pleas which would give you the, let's say, the basis of culpability on which the judges will calculate penalties. So we would look into what kind of defense pleas are typically raised at international crimes trials. Some of them are actually not defense pleas properly speaking, but nevertheless popularly described as the job of the defense counsel, which they are. And then we would look at justificatory defenses that, if successful, would tend to justify the conduct, as well as excuses as defense pleas. Well, until then, I thank you for your attention and I wish you a pleasant week.